It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. There's a reason rappers can turn any story into a hit track. Just like there's a reason Morgan & Morgan is America's largest injury law firm with over 1,000 attorneys and more than 100 offices nationwide. If you've been seriously injured in an accident, your case could be worth millions. But the truth is, a lot of people either don't file at all or get taken advantage of by insurance companies. When you hire Morgan & Morgan, it's like hiring a legal army that has your back. If you're injured because of someone else's negligence, you deserve to be paid. No shortcuts, no lowball offers. In fact, they've secured some major verdicts in the past. For example, in Florida, they got a victim who was in a life-altering car crash, $12 million. 34 times the highest insurance offer. They got another victim in Philadelphia, $26 million. 40 times the highest insurance offer. Not all law firms are created equal. Morgan & Morgan is the biggest for a reason. They will fight for the biggest award possible and have won a lot. So if you're ever injured, you can check out Morgan & Morgan. Their fee is free unless you win. That's right, no upfront costs. They only get paid if you get paid. You can start your claim now by clicking the link in the description or by scanning the QR code on screen from your phone's camera. Again, if you find yourself injured, you can check out Morgan & Morgan. Don't say I never told you nothing, man. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this evening. In this video, we're going to be getting into two subjects. Number one, Tory Lanez. All right. Now, as of today, it has been released that Tory Lanez appeal, which he filed with the state of California to hopefully get another trial for the shooting of Megan Thee Stallion, it has been denied. All right. The appeal is out of here. Okay. The judge has filed a 46-page response, which we're going to be getting into. And secondly, in this video, we're also going to be getting into Megan Thee Stallion. Remember, her and Milagro are going into trial next week, beginning November 17th. And they filed a pretrial memorandum questioning the nature of Milagro's media status. All right. Now, this media status is going to be very vital because remember, just a couple days ago, we read through Milagro's legal team's piece saying that defamation per se should be protected due to Milagro's media status. All right. So with that being said, they're pushing back on that media status crutch that she's trying to lean on because it's already been disputed by the judge in the litigation up to this point. So we're going to get into that filing as well. Okay. But let's start with the Tory Lanez appeal denial because this is going to be the longest portion of the video. All right, here we are. The people, plaintiff and respondent, v. Daystar Peterson, defendant and appellate. Appeal from a judgment of the Superior Court of Los Angeles County, David V. Hereford, judge affirmed by his law firm, Jose Baez, Laura L. Capero, Unite the People, and Crystal Morgan for defendant and appellant, attorney generals, etc. Let's get to it. In December 2022, a jury convicted Daystar Peterson of assault with a semi-automatic firearm on Megan Pete, carrying a concealed unregistered firearm in a vehicle and discharging a firearm with gross negligence. The court sentenced Peterson to 10 years in the state prison. On appeal, Peterson contends the trial court committed a number of errors. We find no prejudicial error and accordingly affirm Peterson's conviction. All right, that's the just let you know right off the bat. Nothing else to be seen here, but then they go into the history of all of this. So we're going to read through the history that we know as the judge presents it. Facts and procedural background. Peterson fires 5 shots at Pete, striking her in the feet. On July 12, 2020, Pete went to a gathering at Kylie Jenner's house. At some point, Pete texted Peterson and told him to come. When Peterson arrived, it was really late. Eventually, Pete wanted to leave. Pete, her friend and personal assistant, Kelsey Harris, and Peterson got in an SUV driven by Peterson's driver, Jaquan Smith. An argument started about the relationships among Pete, Harris, and Peterson. Pete asked to be let out of the SUV. Pete got out and started walking away. She heard Peterson say, quote unquote, dance bitch. Pete turned her head a little bit and saw Peterson pointing a gun at her. She froze. Pete heard shots. She looked down at her feet and saw all the blood. Pete dropped to the ground and crawled into a driveway. Pete felt pain in both of her feet. After that, it got blurry. Pete saw Peterson and Harris walking toward her. Peterson started apologizing, which we also have audio of him also apologizing on the phone. Pete got back into the SUV. They heard police sirens and Peterson told Pete and Harris, please, y'all, don't say anything. I'm about to sign a big deal. I'll give both of you $1 million each. Okay? So he pled with Megan and Kelsey, saying, I'm about to sign a huge deal. Please. This is going to be life-changing. If this situation comes out, it's going to ruin it. And he offered them both $1 million. At 4:27 a.m., Harris sent the text to Justin Edison, who handled Pete's security. The text said, help, Tory shot Meg, 911. Police stopped the SUV. They asked everyone to get out. Pete told the police she stepped on glass. She didn't tell them she'd been shot. When asked at trial why she told the police she'd stepped on glass, Pete referred to the then recent murder of George Floyd. Pete testified she didn't know if they're going to shoot first and ask questions later, and she didn't feel safe with the police officers. Officers found a 9mm Luger semi-automatic handgun on the floorboard of the front passenger seat. The gun was in the slide lock position, meaning all the rounds had been fired from the magazine, emptied. It was warm to the touch, even though it was cold outside at that hour of the morning. Officers also found a bloody towel in the back seat, which we saw photoed, even in the photos that Tory's team tried to put out. The officers took Peterson, Harris, and Smith into custody. At the station, officers checked the hands of all three for gunshot residue. The samples taken from Peterson and Harris were positive for gunshot residue. A criminalist testified at trial that if Harris had been standing within feet of an individual firing a firearm and came into contact with that individual after he fired a firearm, she would not be surprised if Harris tested positive for gunshot residue. Okay? That's also a very big point of contention for those who have been on the side of Tory Lanez, those who have been claiming his innocence and pleading for his release, those that have been pulling for this appeal, okay? So the criminalist said, based on the proximity of the firing and her coming into contact with this individual, they're not surprised that she may have tested positive for gunshot residue. No gunshot residue particles were detected on the sample taken from Smith. An ambulance took Pete to the hospital. Neither in the ambulance nor at the hospital did Pete tell the medical providers that she'd been shot. She later explained, in the black community, it's not really acceptable to be cooperating with police officers. Pete also said that when a woman accuses a man of something, people have a hard time believing you, which she's been dealing with ever since this thing was concluded. The conclusion never seemed to actually end. She added, this whole situation in the industry like a big boys club. Like I'm telling all of y'all's friends and now everybody about to hate me. Which the prophecy was fulfilled. Around 9:05, the morning of the shooting, Peterson called Harris from jail. A recording of the call was played for the jury. Harris told Peterson that Pete was still in the hospital and she was waiting outside. Peterson said, I know she probably never ever gonna ever talk to me ever again, but bruh, I just want you to know, bruh, nigga, I was just so fucking drunk. I never do some shit like that, bruh. You know, regardless, that's not gonna make anything right, and it's not gonna make my actions right, bro. But I'm just deeply sorry, bruh. So, like, I feel crazy, bruh, but made a mistake. Like, what happened, happened already, bruh. I can't take it back, bruh. I'm just telling y'all I'm sorry, bruh. Terrible apology if I do say so myself, but an apology nonetheless. At 8:59 p.m. that evening, Peterson texted Pete. The text said, Meg, I know you probably never gonna talk to me again. Ever. But I genuinely want you to know I'm sorry from the bottom of my heart and I was just too drunk. Nonetheless, shit should have never happened and I can't change what I did. I just feel horrible because I genuinely just got too drunk. I love you and I hope you're okay. Peterson sent Pete other text messages continuing to apologize, just apologizing. Pete had bullet fragments in both of her feet. She had to have surgery and physical therapy. Pete couldn't walk for a while. She can't really feel the left side of her foot. About 4 days after the shooting, Pete told police who had shot her. Pete testified she'd had a change of heart because Peterson had tried to start getting ahead of the story online. He'd put it on a bunch of different narratives about what happened. Excuse me. So as she was trying to protect him, he was already beginning his campaign of how to flip the story in his favor. She took note of it and said, nah, we're not doing that. And if you are familiar with the timeline of events, that's where you started hearing people coming out trying to say what happened. No jumper. Those types of folks. Okay? DNA testing of the Luger revealed a profile of at least 4 people. Peterson could not be excluded or included. His contribution was inconclusive. DNA testing of the magazine also revealed a profile of at least 4 people. Peterson was not one of them. No usable fingerprints were found on the gun or the magazine. In response to the prosecutor's questions at trial, Pete testified she was having a really difficult time sitting up there and trying to comfortably tell her story. Apparently referring to spectators in the courtroom, Pete said a group of people had been continuously spreading misinformation to make her look like a bad person. Okay? Could not be excluded or included. The charges, trial, and verdicts. The people charged Peterson with assault with a semi-automatic firearm on Pete, count 1, having a concealed firearm not registered to him in a vehicle, count 2, and discharge of a firearm with gross negligence, count 3. In count 1, the people alleged Peterson personally used a firearm. In counts 1 and 3, the people alleged Peterson personally inflicted great bodily injury on Pete. So for all the technicality people, the judge is outlining exactly what these charges mean. The people also alleged aggravating factors under the California Rules of Court. The case went to trial in December 2022. Among other witnesses, the defense called Sean Kelly. Kelly testified he lived near Nichols Canyon. In July 2020, Kelly was asleep. He was awakened by lots of shouting and voices. He looked through his window and saw 2 girls arguing. Then they started fighting. They were pulling their hair and hitting each other. It was quite violent. A tall man got out of the driver's side of the car and got involved in the fighting. One of the girls went to the car. Kelly then heard what at first he thought were fireworks. He saw a muzzle flash. At about the same time, a smaller gentleman got out of the back passenger seat. He was shouting a lot. Kelly saw more flashes and what was obviously gunfire. The muzzle flash was near the girls. Kelly did not hear anyone say, "Dance, bitch," although both defense counsel's questions and Kelly's answers were unclear. Kelly seemed to say the girl who was the aggressor went to the car and he saw the muzzle flashes coming from her hand. Kelly then said the flashes came from the shorter man. About 2 weeks into the trial, near the end of the people's case, the prosecution moved to add 2 more felony counts to the information for dissuading 2 witnesses, Pete and Harris, under Penal Code Section 136.1. The court denied the motion. References to statutes are to the Penal Code unless otherwise noted. Counsel didn't ask Kelly about a precise date, referring only to an incident that took place in July of 2020. Kelly testified, "I believe I saw the girls shoot first. They were both shooting. Kelly never saw a gun. He called 911. On cross-examination, Kelly admitted he told investigators that the short guy came out of the car and then he shot the girl. The girl then fell into the road and started bleeding. When asked what was he saying at the time, Kelly replied, a torrent of abuse. It was just all N-words. And F, mother effer. And Kelly also admitted he never mentioned a girl involved in the shooting to the 911 operator, nor did he mention a female shooter to the responding officer. Peterson, as in Tory Lanez, chose not to testify. So he decided not to defend himself in any material way during the trial. The jury convicted Peterson on all 3 counts and found the firearm and great bodily injury allegations true. Peterson, represented by new counsel, filed a motion for a new trial. The court conducted a lengthy hearing on the motion over several days. The court ultimately denied the motion. The court conducted a bench trial on the factors in aggravation under the California Rules of Court. The court found true aggravating factors that Peterson used a weapon in the commission of the crime and that the victim was particularly vulnerable. The court also found Peterson's conduct toward the victim after the incident to be an aggravating factor. The court listed social media posts, releasing songs with lyrics directed toward the victim, attempts to dissuade or perhaps give money to her and the other witness, and violating the protective order. The court stated, I think this is a very significant aggravating factor in this case. The court added, there were 2 times that he violated the protective order where the court had to step in and raise his bail. The court found not true the prosecution's allegation that the crime involved a high degree of cruelty, viciousness, or callousness within the meaning of Rule 4.421A1. Okay, the footnote gives a little bit more information. The trial court increased Peterson's bail several times between his arraignment in November 2020 and trial in December 2022. In August 2021, the court granted the prosecution's motion to increase bail as a condition of bail at the new higher amount. The court ordered Peterson not to attend or appear at events where Megan is scheduled to appear. In April 2022, the parties again appeared before the court to discuss another motion the prosecution had filed to increase bail. The prosecutor referred to a music video where he's depicting violent imagery coupled with lookalikes in the video of Pete and her boyfriend. This apparently was a reference to a music video Pete mentioned in her testimony at trial, showing Peterson chopping up horse legs. Now, I'm sure we've all seen some dark humor, but I don't see the humor in that. Based on the exhibits the prosecution presented, the court found Peterson in violation of both the protective order and the discovery order. Okay? As a condition of bail at the new higher amount, the court told Peterson, sir, you are not to mention Pete in this case or anything about this case in any social media or any public statements, either directly or indirectly. In October 2022, the parties appeared before the court yet again on the prosecution's motion to set bail at no bail. The court denied that motion but ordered electronic monitoring house arrest for Peterson pending trial. The record on appeal includes reporters and clerks' transcripts of the bail proceedings, but not the motions, opposition briefs, or exhibits filed in connection with them. The court also found 3 mitigating factors: that Peterson had no prior record or an insignificant record of criminal conduct, that he had actively participated in charitable or philanthropic causes, and that he did not pose a significant risk of reoffending in a violent manner. Before pronouncing sentence, the court heard from 7 witnesses called by Peterson. The court also listed the authors of 76 letters it had received from Peterson's supporters. A prosecutor read aloud a letter written by Pete as a victim impact statement. The prosecution asked the court to sentence Peterson to 13 years in the state prison. The court sentenced Peterson to 10. The court found the aggravating and mitigating circumstances were a wash. The court selected the midterm of 6 years on count 1, assault with a semi-automatic firearm. The court also chose the midterm of 4 years for the firearm enhancement on count 2, carrying a concealed unregistered firearm in the vehicle. The court sentenced Peterson to the midterm of 2 years to be served concurrently with count 1. The court stayed under section 654. The sentence on count 3, discharge of a firearm with gross negligence. As to both counts 1 and 3, the court dismissed the great bodily injury enhanced under section 1385, subdivision C2, presumably in accordance with Senate Bill number 81. So for clarity, he could have got even more time. Discussion. The trial court did not abuse its discretion in permitting the prosecutor to ask Pete questions directed to her inconsistent reports to police and her attitude about the case and about testifying. Peterson contends the trial court abused its discretion in allowing testimony and evidence concerning Pete's emotions about the incident and its aftermath. On direct examination, the prosecutor asked Pete questions about her initial statements to law enforcement and medical personnel that she'd cut her feet on glass. Pete responded that when a woman says a man did something to her, people have a hard time believing you. Pete said she never wanted to come forward. I didn't want to say nothing in the first place. Defense counsel objected to 9 questions along these lines. The court overruled 5 of the objections and sustained 4. On cross-examination, defense counsel repeatedly asked Pete if she had lied. You also on CBS were asked a couple of times if you had some type of sexual relationship with my client, correct? Yes. And you lied, correct? Yes. You lied on national TV, correct? Yes. You also lied to the prosecutors, correct? Yes. You also lied to Detective Stogner about this issue about the relationship, correct? Yes. On redirect, the prosecutor asked Pete questions that were follow-ups to areas defense counsel had raised. Pete testified people had been making up things and putting out different stories that weren't true, saying that I had never been shot at all. So Pete continued, I had to come out and say, yes, I was shot. I didn't just step on glass. I should have told the truth initially. I know that now. And I thought I was trying to protect people. I thought I was doing the right thing. I thought I was protecting myself, but in the long run, I wasn't. Relevant evidence is evidence having any tendency and reason to prove or disprove any disputed fact that is of consequence to the determination of the action. Even if evidence is relevant, Evidence Code Section 352 gives the trial court discretion to exclude it if its probative value is substantially outweighed by the probability that its admission will create a substantial danger of undue prejudice. The prejudice that exclusion of evidence under Section 352 is designed to avoid is not the prejudice or damage to a defense that naturally flows from relevant, highly probative evidence. The prejudice that Section 352 refers to is evidence that uniquely tends to evoke an emotional bias against the defendant as an individual and that has very little effect on the issues. In general, the trial court is vested with wide discretion in determining relevance and in weighing the prejudicial effect of proffered evidence against its probative value. Its ruling will not be overturned on appeal absent an abuse of that discretion. A trial court abuses its discretion when its decision exceeds the bounds of reason or is arbitrary, capricious, patently absurd, or even whimsical. Put another way, a ruling that constitutes an abuse of discretion has been described as one that is so irrational or arbitrary that no reasonable person could agree with it. Peterson contends the prosecutor's question to Pete regarding how she felt about coming into court today was improper, and the trial court permitting it was inexplicable. Peterson is mistaken. The court instructed the jury, as courts do in every criminal trial, on a non-exclusive list of 11 factors jurors may consider in judging the credibility or believability of the witnesses. One of those factors is, what was the witness's attitude about the case or about testifying? Other factors include, did the witness make a statement in the past that is consistent or inconsistent with his or her testimony, and did the witness admit to being untruthful? Pete's credibility was a key issue in the case. Indeed, in cross-examination, Peterson's counsel repeatedly asked Pete to admit she'd lied. Peterson also asserts this testimony was irrelevant and prejudicial because it elicited sympathy for the victim. However, at the outset of the trial, the court instructed the jury, your verdict must be based solely on the evidence presented during trial in court and the law as I provided to you. The court also told the jury, do not let bias, sympathy, prejudice, or public opinion influence your decision. And before closing arguments, the court again instructed the jurors, you must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. We presume that the jury understood and followed the court's instructions in reaching its verdict. Evidence Code Section 352.2 does not apply retroactively, and the trial court did not abuse its discretion in admitting a photograph of Peterson's torso and arms. So this must be another source of his contention. Peterson contends the trial court reversely erred in admitted evidence of Peterson's creative expression, specifically a photograph that showed tattoos on his torso and arms. At trial, Officer Sandra Cabral testified she and her, and then we have a footnote here. Pete's testimony about being hated on social media for having come forward also was relevant to her attitude about the case or about testifying. When asked, what are some of the things that you were seeing and how did that affect how you felt about coming into court today, Pete replied, Megan should have been shot and killed. I would have shot the bitch too. That bitch lying. Hoes always doing shit like this. Who cares? She fucked everybody. She should have been shot. So these were some of the things that she was saying about herself on social media. Getting back to what the judge states here. Partner stopped a vehicle that matched the description of a vehicle in a radio call they received. 4 people, later identified as Peterson, Pete, Harris, and Smith, were in the vehicle. An ambulance took Pete away, and Cabral and her partner arrested the other 3 and took them to Hollywood Station for further questioning, as the officers had found in the vehicle a handgun that was warm to the touch and in the slide lock position. When they got to the station, they tested Peterson, Harris, and Smith for gunshot residue. The prosecutor marked as exhibits 3 photographs taken at the station that depicted Peterson, Harris, and Smith respectively. In a photo marked as Exhibit 18, Peterson appears to be wearing black shorts or swim trunks. He is shirtless, and tattoos on his chest and arms are visible. In a photo marked as Exhibit 19, Harris appears to be wearing a black 2-piece swimsuit. Tattoos are visible on her arms and left thigh. In a photo marked as Exhibit 20, Smith appears to be wearing black pants and a long-sleeved black top. At sidebar, Peterson's counsel objected to the photograph, arguing it was irrelevant and would only sway the jury because it looks like he's got tattoos. Huh? The court replied the photos were to show who the people are that she, referring to Officer Cabral, took the swabs from. The court continued, I don't see anything wrong. He has no shirt on. He has tattoos. Other than that, what's wrong with the picture? So Tory and his legal team were leaning on the fact that photos were shown that included his tattoos, and perhaps that swayed the jury. At the conclusion of the evidence, the court discussed the exhibits with counsel. When the court asked defense counsel if he had any objection to the admission into evidence of exhibits 18, 19, or 20, he replied, no, Your Honor. In support of his claim of reversible error, Peterson cites Evidence Code Section 352.2, Assembly Bill number 2799 from 2122, enacted that statute, which took effect on January 1st, 2023. This statute requires trial courts to consider certain factors when a party seeks to admit as evidence a form of creative expression in any criminal proceeding. The statute defines creative expression as the expression or application of creativity or imagination in the production or arrangement of forms, sounds, words, movements, or symbols, including but not limited to music, dance, performance, art, visual art, poetry, literature, film, and other objects or media. Peterson cites People v. Venable. In Venable, the Court of Appeal held Evidence Code Section 352.2 applies retroactively to cases that are not yet final. In his opening brief, Peterson failed to note that our Supreme Court had granted review in Venable some 9 months earlier. Peterson also failed to cite either of the 2 cases that reached the opposite conclusion, People v. Slayton and Ramos Super. In his reply brief, Peterson acknowledged the grant of review and mentioned Slayton. Peterson stated he relied on his previous argument pending a final outcome in the High Court. On August 28, 2025, our Supreme Court held in Aguirre that Evidence Code Section 352.2 does not apply retroactively. Aguirre involved handwritten rap lyrics and instant messages attributed to the defendant. Chief Justice Grrrls explained that the High Court, having examined the language of Evidence Code Section 352.2 and its uncodified legislative findings, saw nothing that clearly and unavoidably reveals an intent to depart from the general rule of prospective-only application. Accordingly, Evidence Code Section 352.2 does not assist Peterson. So he tried to use the tattoos as a form of creative expression, which actually did not fall under this specific code. In any event, the record does not support Peterson's contention that Exhibit 18 injected racial bias into the proceedings. Okay, so that's what he was trying to lean on. Black man with tattoos, and they say, oh, scary black guy with tattoos, lock him up. That was what he was looking for. The prosecution did not offer the photograph as evidence of any alleged gang affiliation. There was no gang allegation in this case, and no one ever suggested that Peterson had any gang ties. The prosecution offered Exhibit 18 and Exhibits 19 and 20, and the court admitted them into evidence solely to show the identity of the individuals officers swabbed for gunshot residue at the police station. The record does not reflect whether Peterson was wearing a shirt when police stopped his vehicle. Pete testified they just emerged from the swimming pool. She was wearing a bikini, and Harris was in a swimsuit too. Pete's stylist, Eric Culberson, called by the defense, also testified with Pete and Harris were wearing swimsuits when they got into the SUV. Culberson also testified Peterson was wearing drawers when they left Jenner's house. You said drawers to the police? In his closing argument, Peterson's counsel referred to what Peterson was wearing as his trunks. There was no testimony at trial that Peterson had been wearing a shirt, and the officers asked him to remove it in order to swab his hands for gunshot residue or to take his photograph. Peterson asserts the prosecution explicitly and improperly introduced racial bias into the proceedings by asking a witness about what appears to be a tattoo of a firearm in the middle of Peterson's chest. Defense witness Culberson testified he was Pete's stylist and friend. He sometimes was Pete's driver as well. From the questioning, it appears the defense called Culberson to ask him if Pete or Harris had a gun in their luggage. On direct examination, defense counsel also asked Culberson if he'd ever seen Tory with a gun. Culberson replied no. Counsel asked if Peterson ran around with guns. Culberson answered no. On cross-examination, the prosecutor asked Culberson a series of questions about whether he'd ever seen Harris with a gun or whether he'd seen Pete with a gun at any time that day or night. He did not ask Culberson if he had ever seen Peterson with a gun. On redirect, defense counsel then asked Culberson if he'd ever seen Peterson with a gun, if he'd ever seen Peterson have a bag that had some weapons with him, and whether he'd ever seen Peterson discuss anything about firearms. Culberson answered no to those questions. On recross examination, the prosecutor and Culberson had the following exchange. Now, counsel asked you if you've ever seen Tory talk about guns or if you've ever seen him with guns. Do you recall that? Yes. Do you see the big gun that Tory has tattooed on the center of his chest? He says, no, I haven't seen Tory's body. Defense counsel did not object to that question. In short, the record does not support Peterson's contention that prosecutors utilized Peterson's tattoo, which is intertwined with his rapper persona, to lead jurors to conclude he is a violent criminal with a predisposition to commit crimes. It was defense counsel who asked, both on direct and on redirect, if Culberson had ever seen Peterson with a gun. Neither of the prosecutors even mentioned Peterson's tattoos, much less the tattoo of a firearm, in their closing arguments. So his own lawyer was the one asking and speaking on the tattoo. Peterson also complains that Pete's testimony about a music video Peterson had released poisoned the proceedings by directing the jury to infer that if Peterson was chopping up horse legs in a music video, he was violent enough to shoot her. Peterson seems to be referring to Pete's answer to the prosecutor's question about whether she regretted having come forward. A quote, "If I would have known that coming out and speaking my truth would come with people agreeing with me being shot, if I would have known, I would have started to lose my confidence, lose my friends, lose myself. I didn't ask for this. I didn't want to come out about it in the first place. I started to feel like, damn, maybe I should be dead. I gotta watch Tory drop music videos chopping up horse legs and people laughing at it like that's okay." Defense counsel did not move to strike Pete's reference to the music video, so even his own counsel had no issue with that being an answer. No such music video was offered into evidence or shown to the jury. In any event, Pete's brief reference to the video, which she took as directed at her or even as a threat, was permissible for the same reasons we've already discussed. It's relevant to Pete's attitude about the case or about testifying. The trial court did not impermissibly chill Peterson's right to testify, and as Peterson did not testify, he cannot raise the issue on appeal. Oh boy, now isn't that rich? Peterson asserts the jury did not hear Peterson's account regarding the night in question because the court ruled that if he testified, prosecutors could introduce his music video and rap lyrics during cross-examination. Peterson mischaracterizes the record. That's a fancy way of saying you lied or don't know what the hell you're talking about. Midway through the defense case, the prosecutor told the court he was asking to inquire about prior acts of violence if Peterson testified to rebut the character evidence put on by the defense. The court replied, "Well, I think the state of the evidence as it is now, I would not allow that. Of course, I don't know what he would say if he testifies. It may become relevant depending on what he were to say. But at this point, I will exclude that." The prosecutor listed a number of items with which he proposed to impeach Peterson, including social media posts, rap lyrics, Instagram posts, a 2019 Miami incident, a 2022 incident with August Alsina, an incident with Love and Hip Hop star Prince at a Florida nightclub, and more. The court stated some of this would be admissible, those portions that pertain to this case. Some wouldn't. The court continued, "The best I can tell you at this point is if your client testifies, I'll have to take it on a case-by-case basis, but essentially, anything pertaining to this case obviously is fair game. If it pertains to some other incident, maybe it is, maybe it isn't, it depends." After the defense had called 7 witnesses, the following exchange took place. The court, "So, Mr. Megadesian, you've advised me that your client has elected not to testify." Megadesian says, "That's correct, Your Honor." "So, Mr. Peterson, you know you have the absolute right to testify if you choose." So now they're showing quotes of the judge literally telling him he can testify if he would like. "You have the absolute right not to testify if that's your decision. If you testify, you will take the stand and be questioned just like all the other witnesses were by both sides. If you choose not to testify, I will instruct the jury not to consider it or not to hold it against you. Do you understand what I told you so far?" "Yes, Your Honor." So he was presented very boldly with his right to testify and also his right not to, which he chose to elect. The court, "Have you had a chance to discuss that decision with your attorney?" He says, "I have." "And based on your discussion, is it your choice at this point not to testify?" Tory says, "I will not testify." Neither Peterson nor his counsel ever told the court that Peterson wished to testify, but was deterred by the prospect of impeachment by the prosecution. In Luce v. United States, 1984, 469 U.S. 38, the Supreme Court considered a case like this one in which a defendant did not testify and then argued on appeal. The court had abused its discretion in denying his motion in Lamine to preclude the prosecution from asking about a prior conviction. The court stated, "A reviewing court is handicapped in any effort to determine if a trial court performed the necessary balancing because, to conduct that review, the court must know the precise nature of the defendant's testimony, which is unknowable when, as here, the defendant does not testify. In Luce, as here, there was no commitment by the defendant that he would testify if his request to exclude possible impeachment were granted, nor did he make a proffer to the court as to what his testimony would be. Moreover, a reviewing court cannot assume that the adverse ruling motivated a defendant's decision not to testify, and even if these difficulties could be surmounted, the reviewing court would still face the question of harmless error. The Supreme Court concluded the careful weighing of probative value and prejudicial effect required of a trial court can only be evaluated adequately on appeal in the specific factual context of a trial as it has unfolded. People v. Dong, it is well established that the denial of a motion to exclude impeachment evidence is not reviewable on appeal if the defendant subsequently declines to testify. The Luce court's reasoning is directly on point here. Peterson argues Luce does not apply because 1, that case involved possible impeachment with a prior criminal conviction, and 2, Evidence Code Section 352.2 would have required the court to exclude all of the possible impeachment evidence. We are not persuaded. Nothing in Luce suggests its holding is limited to impeachment with a prior conviction as opposed to other types of conduct, types of conduct or acts. And as we have said, Evidence Code Section 352.2 does not guide us in this appeal. So all of his arguments are pretty much falling flat. The mention of Peterson's criminal case in Florida was not prejudicial. Peterson asserts, inculpatory statements which were inculpatory as to the shooter's identity were improperly introduced in spite of their factual falsity. Peterson apparently is referring to Pete's testimony that shortly after the shooting, when she and the others heard police sirens and Peterson offered her and Harris $1 million, Peterson said, "I can't go to jail. I already got caught with a gun before. Don't tell on me." A few questions later, the prosecutor asked Pete, "What's he saying exactly?" Pete replied, "I'll give you $1 million if you don't say anything. I can't go to jail no more. I'm already on probation." In the defense case, Peterson's counsel recalled the lead detective, Ryan Stogner. Counsel questioned Stogner about his interview of Pete after the shooting. Counsel asked if Pete had told him that Peterson stated, "Please don't say anything because I'm on probation." Stogner began to answer, "It was something to that," when the prosecutor objected. The court overruled the objection. This exchange followed. "Sir, did you do any investigation afterwards to find if my client was on probation at the time this case happened in July of 2020? "Yes." "Was my client on probation, sir?" "No, not to my best recollection, sir." After defense counsel asked Stogner about probation, the prosecutor began to ask a question about it. Defense counsel objected. At sidebar, the prosecutor told the court Mr. Lanez was actually on a Florida-Miami probationary term that started in 2017. She added that, even if that were not the case, defense counsel was accusing the victim of lying about what Peterson had said. Defense counsel stated Peterson got arrested in the Miami case but was never charged. Outside the juror's presence, the court and counsel discussed the matter at some length. The prosecutor told the court the defendant was ordered diversion for a gun possession in 2017. He released an Instagram live video where he talks about going to his probation officer. After more discussion, the court stated, "I will allow you to inquire that there was an incident in 2017. He was placed on court diversion. Don't mention what the arrest was for, and we'll leave it at that." Later, defense counsel and the prosecutor stipulated to advise the jury that Peterson was ordered a grant of diversion for a criminal case in 2017 and that diversion was terminated in April of 2017. The court told the jury the stipulation meant that is a fact that's not in dispute in this case, and they were to accept that as conclusively proven. Both counsel also agreed to a special jury instruction about diversion. In accordance with that agreement, the court instructed the jury about the nature of diversion. The instruction stated, diversion and probation are not the same. You are not to speculate about the circumstances of Mr. Peterson's grant of diversion in 2017. It was terminated in 2017. And you are not to conclude from this evidence that Mr. Peterson has a bad character or that he's disposed to commit crime. Thus, after the prosecution asked Pete about Peterson's statements, defense counsel raised the issue of probation with the detective in an effort to show Pete lied to the police. Pete's testimony that Peterson said he'd been caught with a gun before was not false. In any event, Peterson's counsel reached an agreement with the prosecution to present a stipulation with the true facts to the jury and for the court to instruct the jury on what diversion means. The record does not support Peterson's claim of error on this point. The trial court did not err in permitting the prosecution to play for the jury as a prior inconsistent statement the recording of Kelsey Harris' interview with prosecutors. Peterson contends the trial court reversibly erred in permitting the prosecution to play for the jury its recorded interview with Kelsey Harris. Peterson relies on the Confrontation Clause in Crawford v. Washington 2004. Peterson is mistaken. The issue is one of admissibility under the Evidence Code. It does not involve the Confrontation Clause. The prosecution subpoenaed Harris to testify at trial. The court had appointed counsel for Harris, and the prosecution had granted her use immunity. Once on the stand, to say Harris was a reluctant witness is an understatement. Harris repeatedly claimed not to remember what had happened that early morning and then the days following the shooting. To question after question, Harris replied she didn't remember, couldn't remember, or didn't know. She repeatedly said it was a blur. Several times Harris said she wanted to take the fifth. The court told her she had to answer the questions. Harris repeatedly said, "I don't want to be here." In an attempt to refresh Harris' recollection, the prosecutor played excerpts of a recording of a September 14, 2022 interview. The two prosecutors had interviewed Harris in the presence of her husband and an investigator from the district attorney's office. Two attorneys representing Harris were present on the phone. Again and again at trial, Harris told the prosecutor she'd have to refresh her recollection with the recording. Confronted with her prior inconsistent statements, Harris testified there were some things that she just wasn't being truthful about in her interview. Harris also testified she didn't remember telling prosecutors things that she can be heard saying in the recording. When asked if she had said in the interview that she'd seen Peterson shooting through the window and to the top of the door, Harris replied again, "This is the night of alcohol. I don't know. In light of Harris' claimed failure to recall what she told the authorities and her testimony that she had been untruthful in some of her statements, the prosecution proposed to play the recorded interview for the jury. Citing Evidence Code Section 770 and 1235, the court said it would allow that. Section 770 generally governs the admissibility of extrinsic evidence of a witness's prior inconsistent statement for impeachment. The statute requires only that the witness be given an opportunity at some point in the trial to explain or deny the inconsistent statement. Section 1235 provides evidence of a statement made by a witness is not made inadmissible by the hearsay rule if the statement is inconsistent with his testimony at the hearing and is offered in compliance with Section 770. Where the out-of-court statement is inconsistent with the witness trial testimony, the jury may consider the prior statement for its truth as well as for the light it sheds on the witness's lack of credibility. Jurors may use witnesses' prior statement to evaluate witnesses' testimony and as evidence that information in early statement is true, so the prior statement has a dual purpose. It may be considered for impeachment as well as substantive evidence. When a trial court concludes on substantial evidence that a witness professed lapses of memory are false, evasive devices to avoid truthful answers, it may admit as inconsistent the witness's prior statements describing events the witness now claims to have forgotten. The trial court did not abuse its discretion in admitting evidence regarding an Instagram post. Peterson contends the trial court reversibly erred in admitting an allegedly inculpatory Instagram post, which was disclosed to the defense in an untimely fashion, amounted to inadmissible hearsay and was highly prejudicial, thereby resulting in a manifest injustice. We do not agree. Damn. After the jurors were selected on a Thursday, the court excused them so it could discuss various issues with counsel before opening statements set to begin on Monday. During that discussion, the prosecutors told the trial court and defense counsel that they'd just been made aware of a September 2020 Instagram post by the defendant in which he said a comment posted by someone else that Harris shot Pete was not true. Okay, so this is where he's on Instagram telling people, because people were thinking that Kelsey had shot Megan. He was on Instagram saying, not true. So who else would that leave? The prosecutor gave that information on a CD to defense counsel, who said he'd look at it, but he thought there might be a foundation issue. The following Tuesday, the prosecution filed a motion to admit the defendant's statement on Instagram. The prosecution attached to its motion a photograph of a post by Lil Ju Made the Beat that said this goofy ass nigga say he ain't shooter, and they literally have matched the bullets from his gun to the ones in her foot. Below is the statement, liked by Frosted Cupcake and 281,393 others. Next, by The Shade Room, Megan Thee Stallion's producer alleges that authorities have matched the bullets from Tory Lanez's gun to the ones found in her foot. Under that, view all 13,727 comments. Next, Spliff K says, people saying Kelsey shot her, crying emoji. Finally, a post by Tory Lanez at Spliff K. That's not true. The date on the post is September 25th, 2020. 2 days later, the court discussed the Instagram post with counsel, citing People v. Valdez. The court stated, if the people establish the requisite foundation, namely that this account is linked to a certain individual, that goes more to the weight of the evidence than the admissibility. Detective Warren Eberhardt then testified. Eberhardt stated he had clicked on the Tory Lanez hyperlink and that directed him to an Instagram page where the username was Tory Lanez. Eberhardt explained the blue check on the page was essentially a verification badge. Eberhardt testified the Tory Lanez account has 11.8 million followers. He noted photographs on the account appeared to depict Peterson. On cross-examination, when asked, do public figures have people who run their Instagrams, Eberhardt replied, that's fair to say, yes. Eberhardt testified he'd never said Peterson made the post, adding he could only testify to the username of the account that the post came from. Eberhardt stated he did not know who was controlling Peterson's account. Defense counsel marked as Exhibit E and showed to Eberhardt an Instagram post apparently from user Mid Jordan replying to Messiah Carey. The post states, this is not real. Y'all want to believe anything. I'm the only person with access to Tory's account at the moment. Defense counsel noted the post had been liked by Tory Lanez. Eberhardt testified he'd never seen the post. When the time came to discuss with counsel the admission of the exhibits, defense counsel said he objected to Exhibit 40A, the Instagram post, and Exhibit 40B, photographs on the account on Foundation. The court admitted the exhibits over counsel's objection. Defense counsel moved the admission of Exhibit E. The court stated it wasn't sure any foundation was laid. The prosecution objected on that ground, and the court sustained the objection. The court noted the exhibit's exclusion did not preclude defense counsel from arguing that any post would have come from other people other than Peterson, and counsel did so. On appeal, Peterson complains of late discovery. Counsel never made this objection during trial. He did not ask for a continuance, exclusion of the exhibit as a discovery sanction, or a jury instruction. It was not until Peterson filed his motion for a new trial that he first raised the issue. Peterson has forfeited the timeliness issue on appeal. Shit. Peterson also asserts the Instagram posts are inadmissible hearsay. A trial court's ruling on the admissibility of evidence, including on the hearsay nature of the evidence in question, is reviewed for abuse of its discretion. We need not reach the question of any abuse of discretion here, and we see none in any event because Peterson did not object to the exhibit's admission on this ground at trial. He raised it for the first time in his new trial motion. Peterson's failure to object to the post as hearsay at trial also forfeits that argument on appeal. Shit. Gotta cross your T's and dot your I's. Judgment may be reversed because of erroneous admission of evidence only if an objection to the evidence was timely made and so stated as to make clear the specific ground of the objection. What is this? Peterson filed a declaration of Joshua Farias with his motion. Farias declared he was the manager of Peterson's Instagram account, and he was the person who replied, that's not true. Farias declared, I never consulted with Mr. Daystar Peterson in the posting of that comment on September 25th, 2020. In ruling on Peterson's new trial motion, the trial court stated the Farias declaration was not newly discovered evidence. The court continued, I think that's something that could have been discovered through reasonable means. So this guy claimed that he wrote that on Tory's behalf without even consulting with him. Why would you jump in to protect Kelsey anyway? That don't even make no sense. Anyway, we'll continue. Finally, any error in admitting the Instagram post was harmless. As the trial court noted, the Instagram post was an extremely minor issue in the case. The case turned on Pete's testimony, Peterson's admissions to Harris when he called her from jail, and other similar evidence. Detective Eberhardt testified he was not saying that Peterson had posted the statement. That's not true, and he admitted he had no knowledge of who controlled Peterson's Instagram account. But why you got people running your account that's speaking on intimate details of something that you're being tried for in court? Typically, you would want somebody to fucking post for you. Maybe put some laughing emojis in the shade room comments or something to keep your face out there. Are you crazy? Anyway, the trial court properly instructed the jury on count 1 and the firearm enhancement. Any error in the instructions on count 2 was harmless. Peterson contends the trial court reversibly erred in its instructions to the jury counts on 1 and 2. Count 1, alleged assault with a semi-automatic firearm in violation of Section 245, Subdivision B, and count 2, alleged having a concealed unregistered firearm in a vehicle in violation of Section 25400, Subdivision A1. In count 1, the people also alleged Peterson personally used a firearm in the commission of the offense within the meaning of Section 12022.5, Subdivisions A and D. At the conference on jury instructions, the trial court told counsel it would give Calstrim number 250 union of act and intent, general intent. The court continued. So all 3 crimes here are general intent crimes. Defense counsel did not disagree or object. Peterson's argument on appeal is somewhat difficult to understand. He asserts assault with semi-automatic firearm is a general intent crime, yet the enhancement attached to this count through Penal Code Section 12022.5 requires specific intent. Peterson does not cite any case in support of this contention. No case has held that assault with a semi-automatic firearm or a personal use of a firearm enhancement requires specific intent. To prove assault with a firearm, the prosecution must prove 1, the defendant didn't act with a firearm that by its nature would directly and probably result in the application of force to a person. 2, the defendant did that act willfully. 3, when the defendant acted, he was aware of facts that would lead a reasonable person to realize that his act by its nature would directly and probably result in the application of force to someone. And 4, when the defendant acted, he had the present ability to apply force with a firearm to a person. Thus, this instruction requires a defendant to have acted willfully and with awareness of facts that a reasonable person would recognize would result in the application of force to a person. The jury instruction defines willfully. Someone commits an act willfully when he does it willingly or on purpose, as opposed, for example, to accidentally. The word willfully implies simply a purpose or willingness to commit the act. It does not require any intent to violate law, to injure another, or to acquire any advantage. The word willfully, when applied to the intent with which an act is done, implies simply a purpose or willingness to commit the act. Willfully implies that the person knows what he is doing, intends to do what he is doing, and is a free agent. Similarly, the jury instruction for the personal firearm use enhancement requires only that the defendant personally use a firearm during the commission of the offense. Peterson's contention regarding count 2 requires more discussion. Peterson asserts, likewise, count 2 is a specific intent crime and required instruction with Calstrim number 252. That instruction is entitled Union of Act and Intent, General and Specific Intent Together. To prove the offense of carrying a concealed firearm within a vehicle, the prosecution must prove 1, the defendant carried within a vehicle a firearm capable of being concealed on the person. 2, the defendant knew the firearm was in the vehicle. 3, the firearm was substantially concealed within the vehicle. And 4, the vehicle was under the defendant's control or discretion. Knowledge is not the same thing as specific intent. A requirement of knowledge is not a requirement that the act be done with any specific intent. The words knowing as used in a criminal statute imports only an awareness of the facts which bring the prescribed act within the terms of the statute. However, knowledge is a required mental state for a violation of the statute. For the first time in his reply brief, Peterson cites the bench note to Calstrom number 250. The note states this instruction must not be used if the crime requires a specific mental state such as knowledge, even if the crime is classified as a general intent offense. If the case involves both offenses requiring a specific intent or mental state and offenses that do not, the court may give Calstrom number 252. We review the adequacy of an instruction independently. From the bench note to Calcrum number 250, it appears the trial court should have given the jury Calcrum number 252, listing assault with a semi-automatic firearm and the firearm enhancement, as well as count 3, discharging a firearm with gross negligence, as requiring only general criminal intent, but listing carrying a concealed firearm within a vehicle as requiring the specific mental state of knowledge. However, on this record, the court's failure to do so was harmless. In reviewing a claim of instructional error, the court must consider whether there is a reasonable likelihood that the trial court's instructions caused the jury to misapply the law in violation of the Constitution. We review the challenged instruction in the context of the instructions as a whole and the trial court record to determine whether there is a reasonable likelihood the jury applied the instruction in an impermissible manner. Instructional error requires reversal of the judgment only if it resulted in a miscarriage of justice, meaning it is reasonably probable the defendant would have fared better in the absence of the error. The trial court did instruct the jury that the prosecution was required to prove not only that Peterson committed the prohibited act, but that he did so with wrongful intent and that he knew the firearm was in the vehicle. In closing, the prosecutor argued Peterson knew the gun was there. Of course he did. He grabbed it. He shot Megan with it. Defense counsel told the jurors my client didn't even know the gun was there. Counsel said Peterson jumps in the seat after the girls are in the car. Counsel continued. They're trying to say my client knows the gun was there and he touched the gun and he put the gun there. Why then, counsel asked, was his DNA not found on the gun? In short, the jurors were well aware that the prosecution had to prove Peterson knew the gun was in the vehicle. Jurors are presumed to be intelligent and capable of understanding and applying the court's instructions. Reversal on count 2 is not required. Any ambiguity in Calcrum number 3160 is harmless in this case. On the allegations that in committing the offenses in counts 1 and 3, Peterson personally inflicted great bodily injury on Pete, the trial court instructed the jury with Calcrum number 3160. The instruction states, great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. Peterson cites a bench note following the instruction that cautions courts. This sentence of the great bodily injury definition could result in error if the prosecution improperly argues great bodily injury may be shown by greater than minor injury alone. The note cites People v. Medellin. Definition reasonably susceptible to prosecutor's erroneous argument that the injury need only be greater than minor. And People v. Quinones, upholding instruction containing great bodily injury definition as written. So are you trying to say you only caused minor injury when you shot her in both feet that required surgery? Anyway, any ambiguity in this definition is harmless in this case because substantial evidence established beyond a reasonable doubt that the injuries Peterson inflicted on Pete were more than moderate harm. Indeed, they are more properly characterized as significant or substantial harm. Pete had surgery to remove bullet fragments in both feet. She had a lot of pain and couldn't walk for a while. Pete had physical therapy for a few months. The orthopedic surgeon who operated on Pete's feet testified at trial, and the jury saw x-rays and a report of the operation. The surgeon told the jury Pete was placed under general anesthesia for the surgery. The surgeon described in detail the steps a team of 3 surgeons took to remove questionable tissue and the metal fragments, flush the areas, and close the wounds with sutures. Pete was admitted to the hospital after the surgery. So for the people that believe that her injuries were negligent, reread this statement. I'm not going to do it, but you find it. This statement was more than sufficient to support the jury's finding that Peterson personally inflicted great bodily injury on Pete. Section 12022(7) does not require a victim to have suffered permanent, prolonged, or protracted disfigurement, impairment, or loss of bodily function. Abrasions and bruises to victims' legs, knees, and elbows, neck injury, and soreness in vaginal area that significantly impaired victims' ability to walk were sufficient. Okay, that's in People v. Escobar that they're pointing out. In People v. Wolcott, victim was shot in the leg. Some bullet fragments lodged in victim's arms, little blood loss, no sutures used, victim treated at hospital, then released and went to work the next day. In People v. Elder, victim's finger got pulled into defendant's hoodie and snapped, dislocated finger, all of which fall under great bodily harm. The prosecutor's statements in closing argument do not require reversal. Peterson contends the prosecution engaged in prosecutorial misconduct in making improper comments during closing argument. According to Peterson, these improper comments consisted of improper appeals to emotion and sympathy for the victim, arguing facts not in evidence, and denigrating defense counsel. Peterson implicitly acknowledges trial counsel did not object to any of the statements of which Peterson now complains. The general rule is that a defendant may not complain on appeal of prosecutorial misconduct unless in a timely fashion and on the same ground the defendant made an assignment of misconduct and requested that the jury be admonished to disregard the impropriety. Peterson cites a case for the proposition that this forfeiture rule does not apply if an admonition would have not cured the harm, but he does not explain how admonitions here would not have cured any harm for the prosecutor's statements. In any event, Peterson's claims of prosecutorial misconduct fail on the merits. A prosecutor's conduct violates the 14th Amendment to the federal Constitution when it infects the trial with such unfairness as to make the conviction a denial of due process. In any event, as noted, the court dismissed the great bodily injury enhancement at the time of sentencing. Quoting People v. Morales, in other words, the misconduct or error must be of sufficient significance to result in the denial of the defendant's right to a fair trial. Even if the misconduct is not so egregious as to render the trial fundamentally unfair, reversal is required if the prosecutor used deceptive or reprehensible methods to attempt to persuade either the court or the jury that are reasonably likely to have affected the outcome of the proceeding. Quoting People v. Cash. As we have explained, the prosecution's questioning of Pete about why she initially lied to medical personnel and police, the criticism directed at her after she accused Peterson, and her attitude about the case and about testifying was not improper. Reference to that testimony in closing argument was not improper for the same reason. As for the prosecutor's reference in his opening statement to what he expected Justin Edison to say if he testified, it is not uncommon for counsel on both sides to tell the jury that a particular witness will testify, only to be unable ultimately to procure that witness's appearance. With respect to the prosecutor's suggestion that Peterson tried to bribe Harris in his question, whereas Justin Wright, Pete testified, Peterson said, "Don't tell on me, and I'll give y'all $1 million if you don't tell on me," immediately after the shooting. Harris said the same thing in her September 2022 interview with prosecutors, though by the time of trial 3 months later, she equivocated about why Peterson offered her the money. Harris also told prosecutors she'd met with Peterson outside a hotel a day or two after the shooting, and he asked her if she needed a job, if she wanted to work with him. He also mentioned investing into a business. That don't sound like bribery to you. Prosecutors may argue inferences from the evidence. Prosecutors are granted wide latitude during arguments. When attacking the prosecutor's remarks to the jury, the defendant must show that in the context of the whole argument and the instructions, there was a reasonable likelihood the jury understood or applied the complained of comments in an improper or erroneous manner. Peterson has not made that showing here. Finally, regarding Peterson's assertion that prosecutors denigrated defense counsel repeatedly throughout closing argument, this trial was vigorously litigated and hard fought. Both sides accused the other of misleading the jury. Defense counsel told the jury the prosecution's case was full of holes, and the prosecutors had the audacity to ask the jurors to speculate. Counsel asked why the prosecution hadn't called Sean Kelly as a witness or the investigating officer, Detective Stogner. Counsel queried why the prosecutor had objected to Kelly's testimony. Because they didn't want you to know the truth? Counsel asked. Where's Jaquan Smith? Why didn't they call him? Referring to himself, defense counsel asked the jury, who told you the truth from the first day when I got up here and gave my opening statement? Counsel said, from the opening statement, we had a lengthy discussion when I was informed of this over lunch with my client, with my associate, and my investigator. We came to the conclusion that we're not going to call him because obviously his testimony is going to be putting the gun in the hands of Kelsey. And that's what he told all of us when we just did an interview upstairs. At this point, my position was that the jury believes our theory. I think Sean Kelly already put the gun in Kelsey's hand. And if they're going to believe that he took the gun from him and you started to shoot it yourself, to me, it's kind of an absurd argument. Adding another person to say who has some connections to you as a security or a friend isn't going to do anything. So we decided we're not going to call him this morning. I told the prosecution we won't call him. I'll just move forward into argument. I'm ready. They're ready. Let's just argue and instruct and be done with this. Defense counsel explained further. And the reason for that, Your Honor, is obviously with the holidays coming, my fear is first, I'll lose this witness. This witness made it very clear he's not going to stay here. Secondly, and more importantly, I think we'll have a mistrial and we're going to lose jurors. The court asked, and you talk to your client or do you need to speak further to him? Counsel replied, I've spoken to my client. If the trial continues another 7 days, we'll have a mistrial. My client definitely doesn't want that. My client wants closure on this. He has family flying back out to Canada, and he wants to finish this. To every evidence they've introduced, ladies and gentlemen, they've tried to mislead you. In some, none of the prosecutor's statements constituted deceptive or reprehensible methods that were reasonably likely to have affected the outcome of proceeding. The record does not support Peterson's contention that prosecutorial misconduct interfered with his right to conflict-free counsel. Peterson retained Sean Chapman Holly to represent him in this case. Holly represented Peterson through the preliminary hearing as well as the extensive pretrial proceedings. According to Holly, with trial expected to begin in late November and December of 2022, Peterson wanted to add another lawyer to the team, George McDezian. In a September 6, 2022 email, Holly explained to Brian Gott, who appears to have been Peterson's business manager, Tory has known him for a long time and trusts him. Holly was engaged in an arbitration out of state that began in May 2022. It did not conclude until December 16, 2022, nearly 2 weeks after trial commenced. In a letter dated January 10, 2023 to the trial court, Holly referred to this other engagement and explained Mr. Peterson understood and agreed that George McDezian would represent him at trial and that I would not. An email Peterson attached to one of his pleadings in connection with his motion for a new trial reflects a second reason Holly did not represent Peterson at trial. An email dated November 21st, 2022 to Peterson with a copy to McDezian, Holly stated she was not comfortable advancing a defense theory that it was Kelsey Harris and not Peterson who shot Pete. In Holly's view, it was not a viable strategy. Holly recommended that Peterson discuss with McDezian his willingness and ability to move forward with that defense. The record, again, an email Peterson filed in the trial court, reflects a third issue. On December 18, 2022, Holly emailed Peterson to let him know that she was going to file a motion to withdraw as one of his attorneys of record. Holly stated evidence had been elicited during Harris' testimony that Holly was somehow involved in facilitating an arrangement between Peterson and Harris whereby Peterson would finance Harris' business or something like that in order to curry favor with her, thereby aligning your and her interests as far as the case was concerned. Holly continued, you and I both know that this never happened. Holly added she did not know whether Peterson actually made such a statement to Harris or whether Harris made this up herself, Holly stated. All I do know is that this did not happen, nor would it ever happen. Holly explained, in any event, the fact that these false allegations have been made about me and that they are now evidence in the case makes it a conflict, as in ethical legal matter, for me to continue to represent you, and as a result, I am obligated to withdraw as your attorney. So Sean Holly said, hey, don't put me down with this. You trying to put me down, put me down. I'm going to have to put you down. Because I ain't take place in no conversation about you funding this girl business, being a part of your bribery ideas. Without any citation to the record, Peterson asserts, despite prosecutors' plain acknowledgement that Holly was not involved in the alleged bribery of Harris months earlier, prosecutors opted to wait until mid-trial to raise the exact same allegations, relying on nothing more than Harris' same inconsistent statements dating back to September 2022. Peterson claims these allegations left Holly with no choice but to disengage fully, lest her presence harm her client. Peterson's wholesale failure to support any of these assertions with citations to the record is telling. The letter and emails Peterson himself attached to his new trial motion show the reasons Holly did not try the case and ultimately withdrew. 1. She was engaged in a lengthy 7-month arbitration. 2. She was not comfortable with a defense blaming Harris for the shooting. And 3. After Harris' statements were introduced at trial, she concluded she had a conflict. Nothing in the record supports Peterson's allegation that prosecutors opted to lull Holly into a false sense of security by deceptively assuring her they did not believe her to be involved. The trial court did not err in imposing the midterm. Peterson contends the trial court reversibly erred in declining to impose the lowest possible term. Peterson's sole claim of error on this point is that the court found true the aggravating factor that the victim was particularly vulnerable within the meaning of Rule 4.421A3. There was some discussion in the trial court about whether Peterson qualified for the low term under Section 1170, Subdivision B6. That section provides, unless the court finds that the aggravating circumstances outweigh the mitigating circumstances, that imposition of the lower term will be contrary to the interests of justice, the court shall order imposition of the lower term if any of the following was a contributing factor in the commission of the offense. A. The person has experienced psychological, physical, or childhood trauma, including but not limited to abuse, neglect, exploitation, or sexual violence. B. The person is a youth or was a youth. The trial court found 4 factors in aggravation. 1. That Peterson used a weapon in the commission of the crime, Rule 4.421A2. That the victim was particularly vulnerable, Rule 4.421A3. 3. Peterson's conduct toward the victim after the shooting between the time of the crime and the trial nearly 2.5 years later. And 4. The fact that the court could have sentenced Peterson to consecutive time on count 2, having a concealed unregistered firearm in the vehicle, Rule 4.421A7. The court found 3 factors in mitigation. 1. Peterson had no prior record or an insignificant record of criminal conduct, Rule 4.423B1. 2. Peterson had actively participated. This is a continuation of that other footnote. In charitable or philanthropic causes, and Peterson had a low likelihood of reoffending in a violent manner. The court noted the balancing of the aggravating and mitigating factors was not a mathematical calculation, and some of the factors were much more important to the court's decision than others. The court did not place great weight on the use of a firearm factor, as it was inherent in counts 1 and 3. With respect to the aggravating factor that the victim was particularly vulnerable, the court stated that the term includes being defenseless, unguarded, unprotected, or otherwise susceptible to the defendant's criminal act to a special or unusual degree. The court continued, in determining whether someone was particularly vulnerable, you have to consider all of the circumstances surrounding the commission of the crime, including the characteristics of the victim and the manner and setting in which the crime was committed. And it is not enough for the victim to be in the wrong place at the wrong time. The court noted defense counsel had argued Pete was not young or small in stature or elderly or somehow otherwise limited. The prosecution, the court said, argued Pete was clad in a bathing suit with her back turned. She was unarmed at that time, and she had no idea that this would happen. Also, she was in an unfamiliar area. In addition, it was dark and early in the morning with nowhere to escape to. Okay, so those are all the factors leading to her vulnerability. After hearing further argument from both the defense and the prosecution, the court concluded the prosecution had proven beyond a reasonable doubt that the victim was vulnerable within the meaning of the rule. The court viewed Peterson's post-incident conduct as a major factor in aggravation in this case. With respect to the mitigating factors, the court found Peterson's participation in charitable causes not to be a very significant factor, because who gives a fuck? That's my opinion. The court said the fact Peterson had been an asset to the community and had helped people out was not a recognized factor in mitigation, but was important nonetheless. Similarly, the court stated Peterson's low risk of violent recidivism was not a major factor, but a factor. Okay, so they wanted a shorter sentence. They already had taken it down, but they wanted it even shorter, as in Tory. The only one of these findings Peterson challenges on appeal is the vulnerable victim finding, referring to Harris' statement to prosecutors that she saw Peterson reach toward the center console after threatening to shoot her. Peterson contends Pete should have recognized there was indeed signs that an armed individual may be in the vehicle and thus had the ability to run or duck once she saw a gun being pointed at her. Ah! What? Are you crazy? You clearly are. We find no error. Substantial evidence supports the trial court's true finding on that aggravating factor. Moreover, even were that not the case, no resentencing would be required. The middle term was the presumptive term, and they could have gone longer. The court was not required to rely on any aggravating factors in selecting the middle term, and Peterson does not dispute the presence of 3 of the 4 aggravating factors the court identified. See People v. Yim. Single aggravating factor may support a sentencing choice. All the trial court was required to do in selecting the middle term was to state its reasons. People v. Sarmiento Zuniga. The court did that here. No ineffective assistance of counsel or cumulative error. As we find no ineffective assistance of counsel or prejudicial trial court error, we also find no cumulative error. Disposition. We affirm Daystar Peterson's conviction. Okay? And affirming his conviction means no appeal, no new trial. He shall serve out the remainder of his sentence. So for anybody that was thinking Tory Lanez would get out, there was going to be some type of free Tory party, or that there was going to be some sort of new evidence to be presented, a new trial, or something that would lead to his release. No such thing. Okay? Now, I will resume with the show. I'm sure some of y'all were not here at the very beginning of this video, so I'm going to refresh y'all, all right? So this document that's sitting in front of me, this is a memorandum of law regarding defendant's non-media status, which has been a source of contention in the Megan Thee Stallion versus Milagro Cooper trial, okay? Now, in recent readings, Milagro's legal team is trying to protect Milagro from defamation per se on the grounds that she be protected as a member of the media and that she was simply just reporting, right? Megan Thee Stallion, on the other hand, and her legal team say she is not a member of the media. And they have this memorandum here, which also includes quotes from Milagro herself, stating that she is not a journalist. And also a quote from the judge stating that she is not a journalist, okay? So let's get into it. Memorandum of law regarding defendant's non-media status. The court has already concluded that the defendant is not a media defendant. Okay, see ECF number 36, order on motion to dismiss. That is from the judge based on plaintiff well-pleaded allegations. The court concludes she, defendant as in Milagro, does not qualify as a media defendant. In the motion to dismiss the amended complaint, defendant argued that she was a media defendant and was therefore entitled to pre-suit notice as a jurisdictional prerequisite to being sued. Okay? The DJ that don't spin also tried to lean on that so that he wouldn't need to be deposed. It was unsuccessful. The court rejected that argument, finding that she did not advance sufficient facts to prove her status as a media defendant. Okay, this is a quote. Because the media defendant issue relates to the court's jurisdiction, defendant could have introduced evidence to establish that status, but she does not argue the appendices served that purpose. If the court had found her to be a media defendant, the court would have lacked jurisdiction to hear the case. Stating that pre-suit notice is a procedural bar and a question of jurisdiction. So it's possible if they would have acknowledged her as a media defendant, this could have been possibly dismissed. Nothing has changed since the court's order on the defendant's motion to dismiss, or at least the defamation claim may have been dismissed. Defendant has not proffered or pre-admitted any evidence suggesting that she is a journalist and should be treated as such, nor can she. Any contentions the defendant raises now at this late stage about being a media defendant should be rejected. Even if the court were to search the record today, the facts still show defendant fails to qualify as a media defendant. To determine whether a defendant qualifies as a media defendant, courts look at the defendant's function. As Judge King stated, the function of the media is to inform and initiate uninhibited, robust, and wide open debate on public issues. Internal quotation marks omitted, blah, blah, blah. In Ortega, the court found that a public relations firm was not a media defendant because it does not impartially disseminate information or issue unsolicited, disinterested, and neutral commentary as to matters of public interest, or to editorialize as to matters of public interest without being commissioned to do so by its clients, because PR firms are paid by clients to disseminate information in favor of their client. In the same way, defendant is not a media defendant and has said so herself. Okay, what is this? Of course, defendant was not waiting on any discovery from plaintiff to make a showing as to why defendant should be considered a media defendant. Any relevant evidence, to the extent it exists, has always been within her custody of control, or control, and therefore should have been advanced at the motion to dismiss stage. Whether Ms. Cooper is a media defendant is a gating issue that determines which instructions the jury receives. In other words, it is a question of law for the court. All right, we'll continue. So now they have a quote from Milagro. Everything is not meant to be a news report. I did not tell anybody I was a reporter. Okay, Pease Trial Exhibit 262 from October 29th, 2024. Ms. Cooper says, I ain't never told you I went to school for journalism. What fucking article did I write that I posted and said, y'all read this? What the fuck are y'all talking about? I don't think I'm anything, but I know I'm the person that gets under y'all's skin. You don't need to be a journalist to see something and give an opinion about it. So my whole thing is, if I'm not trying to be a journalist and you know I'm not, what the fuck you mad about? Because I shouldn't be regarded as a news source any damn way. This is a recording from Milagro, October 29th, 2024 live stream. Defendant also stated during deposition, I do not know the ethics of journalism. I don't have a background in that, and I'm not aware. That was from July 21st of this year. Deposition pertaining to this case. Defendant's function, has never been to impartially disseminate information or inform on matters of public interest. Rather, defendant's spread of misinformation, charged commentary on matters that lack a connection with the public interest, such as Ms. Pete's alleged mental status or family background, and evidence of defendant being commissioned by the Petersons to publish her statements, all underscore defendant's non-media status. Okay? And remember, the evidence of defendant being commissioned by the Petersons refers to being paid. Ahead of trial, the court shall conclusively hold that the defendant is indeed a non-media defendant. Okay? So that is their pleading before the trial, which begins next week. Now, here we have audio from Milagro admitting that she did not have a media pass and that she did not enter the courtroom as part of the public as it pertained to the Tory Lanez trial.
They said it was them claiming that Tory ignored you, but that's what they want. That's what they want. That's what they want the narrative to be. They want to make it look like, oh, that bitch just out there desperate to try to do this or that. Once again, I don't have a media pass, and I did not go in as the public. That's a fact. And I want y'all to go do y'all homework. Don't even ask me. Go ask go ask every motherfucker in there from whoever Rolling Stone, whoever the fuck. Go ask them what women have been present on Tory's side. His sister, his other sister, me, and his stepmother. Them the three black women that have been in his corner sitting on his side as family, rooting for him. His brother, he had his son, all of that. Okay? Like all of that. So the fact that anybody would try to make it seem like, oh, this is what this is or this or that is, I would never let no hoe trick me on my spot and make me start to posting shit to prove a point, or like showing certain shit to try to validate a relationship. I don't need to do that because I'm comfortable in my skin. I'm cozy. I don't need to do that. So you can believe what you want. But I just would hope that y'all would do y'all homework so y'all don't be sitting up looking like a damn fool. Because at the end of the day, for example, I just posted that motherfucking picture from ABC News, primetime motherfucking television. And you can see me right there. Okay. And of course, I'm not going to be right next to Tory. It's not about me. So you have Tory and his son. You have his father and his wife hand in hand. You have me, and then you can see his sister behind me. Because the camera's going to be out there crazy. You know? If y'all got footage of us getting in vehicles, you will see what vehicle I got in. So at the end of the day, um, these narratives are ridiculous.
All right. Now, that audio we just played was of Milagro feeling very comfortable in her position, whatever that position may be, as a so-called sister to Tory Lanez. She felt like she was protected, like she was doing the right thing, and that her spot inside the camp, the family, whatever you want to call it, was solidified, during the time of that trial. Now it is 2025. The tune has changed significantly. As a matter of fact, earlier this year in May, she denounced her support for Tory Lanez and regretted it. So I just want to play that real quick before we conclude.
Still fucking there. And I hate, and I told y'all I could feel it creeping in, but I hate that I know that I will never go hard for a nigga again in my fucking life. Ever. Ever. And to have somebody like me, I know how important that is, but when I tell you this has absolutely jaded me, and I would never get up and da 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 and ride for a nigga, regardless of if God. I don't want to say I'm gonna go against my God because I feel like God put Torah in my heart. But if it came again, bitch, I go against it. I fight it until God made it to where I just couldn't ignore it. But I was asking while we were going through everything, why won't nobody say nothing? Why won't nobody stand? Why won't nobody do this and that? Why? And then you live and you see. And that's really unfortunate when you got a bitch with heart that's willing. But fool me once, shame on you. Fool me twice, bitch can't get fooled again. So I hate every nigga that won't have my support moving forward. That's what I hate, honestly and truly. I hate every nigga that won't have a Milagro in that corner. And I hate all the people that took a Milagro for granted too.
I appreciate you so much. I'm finna go smoke. I love you.
All right. Now that was after Tory Lanez and Unite the People and everybody basically pulled their support and resources from her as this case continued. All right. So everyone that she thought would have her back, as she had his, and at a certain point, the support was pulled. All right. So just goes to show you, man. You could pull for this guy all you want, and now you in a world of trouble because of him when you never had to insert yourself. You could have just covered this stuff like anybody else, imparted your opinion, whatever that may be, and went about your business. But you wanted to get a position within whatever the fuck they had going on. You got that position. You thought you was untouchable. And what Ray J say? You got touched. Now, again, the trial will begin next week, November 17th. So we still have some time to see what is going to happen, what the judge is going to allow to continue, how they're going to handle this whole media defendant situation. Very interesting. But again, Tory Lanez's appeal has been denied. He will serve out the remainder of his sentence. The Milagro Megan Thee Stallion trial will begin next week. We'll see where it goes from here. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider, and I will catch y'all on the next one. Y'all be good out there, man. Peace.
Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'm never politicking, the drama be piling on. Father and great son acknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5 sit bank accounts, every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I'll turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy calls, consulting for the stakes I built. I had